Jai Shri Ram. Let's learn some legal phrases which I am certain will be very useful even in our ordinary non legal lives. Absurd mistake. Now, this is an interesting phrase, absurd mistake. What is an absurd mistake? Well, I leave it to you. I leave it to you. Abuse of discretion. Now, discretion means the authority to take decisions. So, abuse of discretion. Well, many people constantly guilty of this. Okay. Next, abuse of process of court. Yes, this is a phrase we can use in case if we are entangled in some litigation. We can tell the judge or the lawyer to use this phrase, because abuse of process of court will be the abuse that is when any action, to allow any action which would result in injustice and prevent promotion of justice. When fake 498A dowry harassment cases, fake cases are filed, and if you are a victim, then you must keep repeating this, chanting abuse of process of court. At least some judge will listen. Okay. Next, accidental omission. An accidental omission may be attributed to the judge himself. He may say something or omit to say something which he did not intend to say or omit. Act done under the color of duty. That is self-explanatory. And demanding of a bribe by a police officer after taking advantage of his position. But I believe it does not amount to act done under color of duty. There is a case, Bhanu Prasad versus State of Gujarat, EIR 1968 SC 1323. Anyway, act done under color of duty. That's a nice phrase to use to explain situations which you might sometimes get into when you are under duress and when you are being cornered to pay some illegal gratification. An adhesive contract, interesting term, adhesive, like Fevicol. Adhesive contract means a weaker party has no realistic choice as to its terms. Adhesive contract. The weaker party has no realistic choice as to its terms. Adverse possession. Adverse possession is hostile possession, denial of title of true owner. Adverse possession. The aggrieved person. An aggrieved person is a person against whom a decision has been pronounced which has wrongfully deprived him of something, or wrongfully refused him something, or wrongfully affected his title to something. That is the aggrieved person. The aggrieved person also means one who has got a legal grievance. A legal grievance is there. Such a person is called an aggrieved person. An arguable issue. An arguable issue is an interesting phrase. I think we can use it in religion also. Arguable issue simply means when there is some doubt about the situation and questions can be raised, and there are obscure points which require elucidation and on which several views are perhaps possible. That's an arguable issue. Well, in simple English, I think it's a moot issue. As far as may be practicable. As far as may be practicable implies not that it is mandatory that the proceeding must be concluded within a period of 2 months. Rather, it's a directory. As far as may be practicable. As far as practicable is also used. A bona fide dispute. Now, a bona fide dispute is when the parties intend to press their claim to a property. It's a bona fide dispute. Benefit of doubt. Benefit of doubt means real, genuine, well-founded doubt, which a normal man with normal intelligence in a given circumstances would naturally harbor. These are doubts which come within the fold of reasonable doubt. entitling one to the benefit thereof. State versus Sarangadhar Bhoi, 1972, CUT LJ 734, benefit of doubt. Bylaws, BYE-LAWS, that is laws that we create to run our organization. Laws, regulations and constitutions of corporations to govern the members of a particular organization or institution. They are called bylaws. Carnal knowledge of woman. This is a complicated euphemism for sexual intercourse by adultery or rape. Carnal knowledge of woman. Oh my God. Cause of action. Cause of action means the plaintiff has to prove his right to judgment of the court. It does not comprise every piece of evidence which is necessary to prove each fact, but every fact which is necessary to prove each fact, but every fact which is necessary to be proved. So the phrase cause of action means the plaintiff has to prove his right to the judgment of the court. Civil proceedings. Civil proceedings covers any proceeding of a civil nature and includes proceeding held by high courts too. Coparcenary property. COPARCENERY. Coparcenary property means the property which consists of ancestral property or of a joint acquisition or of property thrown into the common stock and accretions to such property. So that is why you say, I remember my maternal uncles, they made sure that the ancestral home, as kids, we were some 20 cousins. We used to meet every summer holiday. But my uncles made sure that as soon as my grandfather died, they sold it off, converted it into flats quickly, and sold all those flats off and made money and gave nothing to their sisters, the big family. So obviously some lawyer must have told them, because if they don't do this, then the sisters, there were just 3 brothers and 8 sisters, so they denied the sisters any possibility, because some lawyer would have said this can be called coparcenary property and they should all get shares. So to avoid this, this is how the so-called brothers are cheating their own sisters. This is Kalyug, Baba. So don't get carried away and don't be obsessed and infatuated with your relatives. Your own brother could backstab you and prevent you from getting what you legally should get. Whereas the Veda says putrena duhita sama. Manu also echoes the same sentiment. That means the daughter is equal to the son, which itself is a simple direct command that you cannot and should not treat your daughter as inferior in any way. Putrena duhita sama. Criminal contempt. Criminal contempt means highly objectionable and scandalizing remarks about the courts. That is criminal contempt. Criminal negligence is culpable neglect or failure to exercise reasonable care or precaution when guarding against injury either to the public generally or to an individual in particular, which having regard to all the circumstances out of which the charge has arisen, it is the imperative duty of the accused person to have adopted legal language. Criminal negligence, understandable, simple phrase, useful phrase. Curative statutes. Curative statutes attempt to correct errors in judicial or administrative proceedings, which seek to give effect to contracts and other transactions between private persons, which otherwise fail to produce their intended consequence on account of some statutory disability or failure to comply with some technical requirement. Curative statutes. Customary rites and ceremonies. Customary rites and ceremonies can mean the custom as an essence of marriage ceremony that had been followed from ancient times, and that the members of the caste, community or subcaste had recognized such ceremonies are as obligatory. The doctrine of unjust enrichment. Doctrine of unjust enrichment. The basis of the law should be restitution, where it is unreasonable and unjust for the defendant to retain the benefit which he has received. Doctrine of unjust enrichment. Due process of law, due course of law. Due course of law in the normal proceedings, a simple phrase. Failure of justice. Failure of justice is when there is no fair trial and just decision of the case. Nekiram and State of Haryana, 1974, 76 Punj LR 780. Failure of justice. Fraud and dishonesty. If there is the intention by the deceit practiced to cause wrongful loss, fraud and dishonesty. Dishonesty, but even in the absence of such an intention, if the deceitful act willfully exposes anyone to risk of loss, there is fraud. The fundamental principles of justice cannot be interpreted in a way so as to include mere want of jurisdictions or excess of jurisdiction. Municipal Corporation of Greater Bombay versus K.C. Sen, EIR 1952, Bombay 209. The fundamental principles of justice dictate that simply because there is no jurisdiction or excess of jurisdiction, justice cannot be denied. Habitual defaulter. A habitual defaulter fails to deposit accepted rent, makes the person a habitual defaulter. Habitual defaulter is one who is constantly violating some rule, law, or some obligation. Default means to fail to pay. And default can also mean, not following propriety and decorum and all that. A habitual offender. A habitual offender is one who is a criminal by habit or by disposition formed by repetition of crimes. Habitual offender. Hostile witness. If a hostile witness is turned hostile, his entire evidence is not to be discarded. So, hostile witness, works against the person who invited him to give evidence in his favor. Leading questions. The court permits leading questions in matters which are interlocutory or undisputed, which have, in its opinion, been already sufficiently proved. Leading question may be proved in cross-examination. Living in adultery. Living in adultery means an adulterous life of a quasi-permanent or a more or less continuous course of conduct. Living in adultery. A perverse order. A perverse order means an order made in conscious violation of pleadings, and the law would be perverse order then. Popular sense. Popular sense means the sound mental faculty of the people to understand the subject matter. The statute is dealing with popular sense, in popular sense. Nice phrase to use. A premeditated act. A premeditated act means a determined act or an act deliberately intended, not sudden or accidental. Reason to believe means that is believe and it is not arbitrary or capricious but based on or justified by facts. Reason to believe. That means you are believing and it is not arbitrary or capricious but based on or justified by facts. So, some related phrases are reasonable cause, reasonable doubt. Reasonable doubt. Complete proof for the prosecution cannot fall short of elimination of reasonable doubt about ingredient of an offence. Reasonable doubt, reasonable restriction, reasonable opportunity must be given. Reasonable suspicion depends upon facts of each case. reasonable suspicion. Rule of law means the law must not be arbitrary or irrational, and it must satisfy the rest of the reason. Scandalizing the court means hostile criticism of judges, that is scandalizing the court. Unfair advantage. Unfair advantage is advantage obtained by unrighteous means. Ganesh versus Vishnu 32, Bombay 37. Advantage obtained by unrighteous means is unfair advantage. Vested in court means power conferred by statute. Vested in court. 0 hour means the time set for the beginning of an attack or other military operation. 0 hour can also mean any crucial or decisive moment. The usually noisy interregnum between the question hour and the beginning of the rest of the day's business. The noisy interregnum between the question hour and the beginning of the rest of the day's business in legislature is also called 0 hour. Between the question hour and the beginning of the rest of the day's business. Members raise, often without notice, various matters during this period. That is the 0 hour. Between the question hour and beginning of the rest of the day's business in legislature. Jai Shri Ram.